Thank you very much. Yep, as just said, my name is Nate Bailey. I'm a representative of Our Family Withered, which is a shared communication platform for separated and divorced parents. I'm very honored to introduce our speakers today. Today we have Kate Power, who is an assistant county attorney for Boulder County. She has represented Boulder's Child Support Services Unit for 7 years, and for 2 years prior to that worked as a child support court liaison. Kate has served on the Colorado Family Support Council, my apologies, and on child support state work groups. Additionally, in her role as ACA, she covers mental health and substance use commitment cases, public benefit appeals, and adult protection cases. Now, Nicole Ketcherside is an integrated case manager at Boulder County Child Support Services. With more than 7 years of experience, she has worked to initiate, establish, enforce, and modify child support orders. Nicole supervises the court liaisons and supports the department with community outreach and educating the Boulder County community about the child support program. Without further ado, I will pass it off to our speakers.
Hi there. Thank you so much for being with us. And I just want to say it's a little bit funky presenting like this because we can't see ourselves on the screen, nor can we see you. So I'm just going to pretend there's a big audience here that's captivated listening to us present. And thank you for the introduction. We are here to talk about child support services, the program basics. We're hoping that this will give you an opportunity to learn a little bit about child support services overall, and also to leave with a PowerPoint that has some good reference materials in it. No. Good morning, I'm Nicole Ketcherside, and thank you for the lovely introduction. It's a pleasure to be here with you today, and we hope that we can share some information that you can take with you and provide just some good networking amongst yourselves, and also to provide some good quality information to your clients as you navigate the child support world. We know it can be complex, so that's why we're here today. Thanks. Could I ask you just to scooch the slide along? Sure, thank you. And I think, yep, our first slide we took care of already, the introductions. So just to give you a brief overview of what we're going to talk about today, the PowerPoint is really structured into two different segments. The first segment, we're going to talk about the legal authority for the Child Support Services Program. I'm going to include some citations. If you really want to dig into child support, we're going to talk about the federal law, the state law, and then go a little bit into how you might see child support services programs vary county to county, depending on where you're working. We will focus a little bit more on Boulder County, just because that's where Nicole and I hail from. And then the second part of the presentation, we're going to talk a little bit more about the nuts and bolts of child support services programming, and really what to expect when you see child support services intervene in your court case, or if you have clients who might be interested in getting services from child support, getting assistance from child support, and what they can expect, and what they shouldn't expect from us. So to start really broad, the Child Support Services Program is actually a federal program. It is the authority for the program comes from under Title 4D of the Social Security Act. And we're not going to go into all of the code and the regulations because there's a lot. But I did just want you to have the citations in case you are interested in the breadth of the program. Every state does have a child support services program, and the authority comes from the 4D Social Security Act. So we have the United States Code 42, Chapter 7, and then we also have the Code of Federal Regulations, which provides a little bit more of the nitty-gritty about how child support services programs need to operate. They talk about what child support services programs needs, for example, their guidelines, timelines for case management, when to open cases, when to close cases, things like that. And then we also have policy guidance at the federal level that comes from the Federal Child Support Services Office. That's not quite as frequent as the state policy guidance, but we do see some federal guidance that comes through that the state implements, and then it trickles down to the county services programs. Then, of course, we have the Colorado law. So the second little umbrella under the big umbrella. And child support law pops up in several different titles under the Colorado revised statutes. Child support services programs obviously works with the child support guidelines. So under Title 14, the domestic matters title, we have the guideline statute, the statute for public assistance benefits or TANF benefits specifically. That's under Title 14. And the reason that that's important is because if you have a client who's on public assistance or TANF, then they, under law, assign their right to support to the state of Colorado. And that's when child support has to get involved with some exceptions. And we'll go further into that in a few slides. Title 14 also addresses income assignments, and then the Uniform Interstate Family Support Act, which is the authority that what gives us the authority to establish or enforce other states' child support obligations. So if you have a client who has an order out of Florida and they are now in Colorado and they want help enforcing that Florida child support order, that's what UFSA authorizes us to do. We also have some authority under Title 19, the Uniform Parentage Code. Child Support Services has the authority to help establish parentage if that's necessary prior to a child support order being entered. And then Title 26 is the Human Services Code, and that's where you'll find a lot of child support's authority to, for their administrative actions. Child Support Services can establish orders administratively, and we'll get into that in a little bit. But you'll find a lot of our other authority there, including enforcement actions. So things like liens, suspensions of driver's licenses, things like that. And then, of course, we have the Colorado Code of Regulations, that's volume 6. And if you are befuddled why a child support services unit is doing something or not doing something, and you can't find it in one of the statutes, I would suggest checking out volume 6. It is just scintillating reading, but it does have a lot of information about, timelines, things that we have to do for confidentiality, things that we can and can't do. And then, of course, there's state policy guidance that we have to follow. So there's the federal law, there's the state law, and then there's a little bit of variation between the counties. So child support services programs are governed by the state and federal laws, as we talked about. But then there's also a little bit of wiggle room within the regulations for counties to take different approaches in very specific instances. So for example, interest, when under the law, unpaid child support could accumulate interest. And some child support services units calculate and enforce that interest. Volume 6 says we can, or when I say we, I mean child support services units, but it does not say that the units have to do that. So Boulder County does not calculate nor enforce child support interest, but other counties may. And that's not to say that your client couldn't independently calculate and enforce that. It's just something that child support services doesn't do. And then there's some different ways to handle public assistance debt. And then there are specific services that counties might provide. Nicole is one of our amazing case managers, and part of her specialty is to provide people with resources such as educational resources or job opportunities for folks that maybe are having trouble meeting their child support obligation due to obstacles or barriers. So we offer some intensive case management and resource management that other counties might not. And some counties might have other programs that we don't. And it occurred to me when I was rehearsing these slides that this one would have been the best to put at the beginning of the program, but here we are. Now you have the outline of the law. And this is really to encapsulate what child support services does. So in a nutshell, child support services is a program that's meant to assist parents and caretakers to get financial support for children from both parents. And as a part of that, child support services is authorized under all of those laws that we just went through to locate non-custodial parents. We can establish parentage and complete genetic testing if that's necessary. I put in this piece about parenting time due to a change of law, and I'm going to circle back to that because it's important. But I'll do that at the end of the slide. We can establish new child support orders. We can enforce ongoing child support orders. We can modify child support orders when appropriate, either administratively or through the court. We can collect and disperse child support payments and also maintenance payments in certain circumstances. We can register and enforce out-of-state cases if that's necessary, or out-of-state child support orders. When there's public assistance involved, then we'll we have mandatory involvement with child support cases. And then we also establish and enforce medical support, which just the easiest way to think about that is insurance costs from employers when appropriate. And I do want to distinguish, we don't enforce unpaid medical debt. So like if there's a surgery and there's cost associated with the surgery, we don't enforce that cost. It's really the medical support as insurance. And I did want to circle back before we move on to the parenting time piece. So child support services does not facilitate parenting time issues or disputes, and we don't have the standing or authority to do that. But there was a recent law change that allows parents to file a motion to establish parenting time in their child support JV action. There was some law about it previously before the law change, but it really clarified that moving forward, parties can do this in their JV action, and they can have everything heard in their JV action. So say a child support services unit starts a JV case to establish a support order, a parent can now file a motion for parenting time into that JV action. And we can provide resources for parties. There are some template motions that the court has provided that we can offer to parties, but we can't be involved, or the unit can't be involved in negotiating or filing that component.
Thank you, Kate. So I'm going to pick up from here for just a few minutes and discuss the establishment piece of child support. And I'm just going to touch on a few key points here. Parties can apply directly to child support services, or they can be referred to us on what we call a mandatory referral. So if a party is receiving public assistance through the county, they are required to cooperate with child support services. And so we want to make sure that at the intake level, when they are meeting with whatever those public assistances may look like, that they are told at that point, you know, you are going to be mandated to cooperate with child support and open a child support case. With that said, it's also free to apply. There is no cost for parties to apply for our services. There is an exception, and we call it good cause. So if a party does apply for public assistance and they have a factor that would prevent them from applying to child support, such as a domestic violence situation, something like that, those factors are discussed at the intake level. And if they are found to have good cause, they would not be referred to us because we want to protect our customers or our clients from situations that could be hurtful to them or their families. Also, foster care. We are no longer mandating referrals on foster care. So we are no longer enforcing or establishing foster care orders. The foster care program is still moving along as it has been, but child support is no longer involved in the enforcement or establishment of arrears on foster care. And an application can be submitted to simply request support of child support, and we can do support and parentage. So we don't do paternity only. It goes hand in hand with support, but we can do both. And establishment can occur at either a judicial or an administrative level. And so if we meet with a client and we are working towards establishment after they've been served, and it's determined that we think there may be a need to deviate from a guideline, we don't have authority to do that. In that circumstance, we would kick it over to judicial and have the case heard before our magistrate.
And just to dive a little bit into, oh yeah, the next slide. That's good. Thanks. And just to dive a little bit into the last thing that you just said, Nicole, to clarify a little bit further, under Title 26, there's something called the Administrative Procedure Act, which gives child support services units the authority to actually establish a child support order administratively without going to court in certain circumstances. So you might see, if you come into a case and your client says, oh, I had a child support order already, but I never went to court, that it might actually be the case. And it happened, and Nicole will talk a little bit more about when we establish these orders administratively. So when you hear us talking about administrative establishment or modification, it's something that the unit does without having to have a court hearing. And we do have authority under Title 26 to effectuate those orders. They are filed to court, but again, Nicole will talk a little bit more about that. But if we're not in administrative land, or we call it APA land, then we will have a judicial establishment of a child support order, which under what you might think of as a typical court process. We get an application for child support services. There needs to be support or support in parentage. The parties don't want to have an administrative order, so we'll set it for court. And we'll have a hearing. Cases will always be established judicially, not via APA or not via administratively. If parentage is contested, if one or more of the parents is a minor, if the parties want a court hearing, which is very frequent in my experience, or if the court has previously exercised some kind of jurisdiction over a child support issue. A good example is if someone filed a DR action that was ultimately dismissed, it's likely that we will not go forward in administrative land, we'll be in judicial land to establish child support. At the hearing, a child support attorney, a 4D attorney, myself, or one of our co-counsel, Lindsay Peterson, who's amazing. She wasn't able to be here today, but we'll be there to help facilitate testimony and get evidence in front of the judge. We don't represent either party. We're really there. I see our role there as to help facilitate getting the information that the judge needs to make an equitable order for both parties. And just really briefly, retroactive support can be addressed to the date of application for services with child support. We won't ask the court to establish retroactive support prior to a party's application for support services, but parties can do that independently of our.
And so now we'll jump into the administrative or APA land, as Kate referenced it. And so again, child support can establish orders without going to a court hearing. And we do that by a negotiation conference. We call this an administrative or APA conference. We can also establish orders of default, and these orders of default also usually include what we call a temporary order. And so once we have established that the client is in default, they haven't appeared for their conference, they were served with the proper documentation, and they did not appear, we can enter the default order, submit the temporary order to the courts, and the case still remains administrative at that point. And so that's one thing that a lot of folks, tend to get confused on, because we are filing these items with the court, but it's our order and we are not asking the court to make a decision on our behalf. It's just part of our process that we have to get everything filed with the court. So the case would remain administrative. And so typically when a case starts with child support, when we're the ones establishing the order, that case, it's a JV action. However, sometimes along the way, we may find that a DR action exists, or a party will go and open a DR action after they've already applied for our services. And so in those situations, we may enter into that DR action, and then the JV would simply no longer exist. We'd just be working out of the DR. And subsequently, we can modify that order. So if the order starts administratively, we can also modify it administratively. We don't have to do that through the courts. But in certain situations, we find the modification does need to be done through the courts. There may be a good reason for that. At that point, the case would become judicial. And then also a good piece of information here, if you are counsel for a party who is part of a child support action and you're representing them in that action, we do need you to provide written notice to child support so that we can be sure to include you in all of the actions and documentation that are occurring in the child support case.
And just can I add one thing?
Yes, please.
Okay, great. So something else, it's not infrequent, I think, that we as a child support unit start these cases APA, parties really want to get their child support going, and then someone else files a DR action. And a lot of times they're existing in parallel until we file our APA order into that DR action. And just so you know, that APA order will survive a DR dismissal unless the court specifically dismisses the APA order as well. And we try to include, and I know that this is a lot of information, so we try to include the sites if you want to take a look at it. The APA stuff can be pretty complicated, and I think it's kind of unusual. So we're happy to answer questions at the end if you want to pop them in the chat, or we'll have contact information if you need any of these pieces clarified.
Absolutely.
Is this me? It is me. Okay. So we talked a little bit about modification. So with child support, you start with the establishment of an order, and then I want to say almost always someone is going to want that order changed. There could be a change in jobs, there could be an additional kiddo or an emancipated kiddo. Something happens and parties want to get their child support obligation changed. And we as a unit do provide modification services to parties. Either party can ask child support services to start what's called a review and adjustment in our office. And that's really our office taking a look at what's happening with child support and what's happening with the financial circumstances of the parties, running new proposed guidelines to see if a modification of support could be warranted. So either party can ask for it. Something also to note that there's a statewide database for child support called the Automated State Child Support Enforcement System. That's looking at orders. And if there's an order that it's looking at it like it's a person, it's not, it's just like on an automated thing. But if there's an order over 36 months, then sometimes ACES, that's the database, it will ask child support to start a review and adjustment without either party asking. So if you see a modification coming down and parties are saying, hey, no one asked for this, it could be that it's a system generated modification, and that's when the department is asking the court to look at child support. And there's a negotiation process. We try to work with parties to come to an agreement before we have to have a modification hearing. We have a really fabulous modification technician who works really hard to get to an agreement place. If there's no agreement, then we do set it for hearing and ask the court to hear the issue of modification. And then something else to note, just if your client is looking to child support to process a potential modification, we're required under Volume 6 to follow the modification through once we've started. So if your client is hoping for let's say a bump up in child support, we run the guidelines and the guidelines show that it goes down, your client can't say, oh, never mind, I don't want the modification of support. In that circumstance, we have to continue, which would either mean filing a motion to modify on the proposed guidelines or asking the court to set a hearing. We will also do, we will also enforce child support arrears only cases. Even if there's no longer an ongoing support, all the kiddos have emancipated. We actually have a technician whose sole job it is to enforce arrears only cases. We do have some limitations on enforcing just maintenance arrears in that we can't do that if it's just maintenance left on the ledger. We're not authorized to enforce just maintenance cases. And just to know, if there is a court-ordered payment on the arrearages, if the court entered, you have to pay this off over 24 months or something like that, then enforcement remedies may apply to that case, even if there's not ongoing support. And we'll talk about what enforcement remedies are in a few slides, and how they might impact your clients. Child support, unpaid child support becomes a judgment when it's due and not paid. That's under statute. But like many judgments, it will not, child support judgments will expire after 20 years unless they're renewed. And child support services, at least in Boulder County, we don't renew judgments. But again, parties can do that independently of our office if they would like to do it. And as Nicole stated, previously child support services was mandated to establish orders for parents to pay foster care fees. If a child was in billable foster care, that's no longer a requirement. And so we are no longer pursuing foster care arrearages either.
I'll take over here. And so we're going to speak a little bit on enforcement of ongoing child support orders. And so the intention behind enforcement is not to be punitive, but to ensure compliance with ongoing child support obligations. And we really want to support our families as a whole and identify potential barriers and things like that to paying or receiving support. So we really want to look at the family as a whole, not just only at the payer per se. We can issue income assignments. And so typically what we'll do is confer with our paying party to identify if they have an employer. If they don't, we want to provide them services on ways where they could find employment. And so once we identify an employer, we would send an automatic withholding or an income assignment to withdraw. We also can withhold directly from their bank accounts, which is called a RAW. These payments are all processed through the Family Support Registry. And that's also known as the FSR. The FSR essentially talks to ACES, our system within child support, and tracks the ledgers. So we can identify what's been received, or what's been paid, what's been received. And the clients also have access to this information through the Colorado Child Support website. And so we know that there's a lot of situations where they want to, see what's been going on. And the FSR is essentially their bank account for child support purposes. We can adjust ledgers and complete arrears calculations. Those are things that we're frequently asked to do. Also, Department of Correction obligors, they receive a minimum order. And right now the minimum order is $10. And the intention behind that is to reduce the current support amount because we can't enforce a zero amount. The least we can do would be the minimum order of 10. And the intention is that when a payer is in DOC, that they are not racking up arrears that they'll never be able to get out of, or have a difficult time paying off when they're in Department of Corrections and they can't pay. So that's why we have the minimum order there. And then also our child support technicians, we all have assigned caseloads, and we monitor those for compliance via the FSR and our system ACES. And we're always available to speak with clients about their orders or any questions or concerns they have, offer county services in any way that we can, but we cannot provide information about opposing parties. And so I will speak on this a little bit more in some future slides, but we just want to give some clarity in this area. There are situations where the court may ask us to provide something, but we have to be really careful about the information that we're sharing. We're just not permitted to share certain identifying factors, especially if we have a party, whether it's the payer or the recipient of payments. Regardless, if they have non-disclosure of information, we have to be very careful about what we're providing. So
yeah. Can I add a couple of
things? Yes, please.
Okay, great. So, and I think when I was referring to like volume, you might be wondering why child support services is doing something because you can't find it in statute. This is a volume 6 requirement that child support services units are only allowed, if a party calls, child support services is only allowed to provide that party with that party's information. We can't provide them with the other party's information. So if your client wants opposing parties like so let's say address and phone number, and they call and ask our unit for it, we might have that information, but we cannot provide it. And that's what that's about. And then just under the DOC information, that's not automatic. We do work to modify those. We have the system review that ACES will review when someone has a sentence over 180 days. But I just wanted to make sure that's not automatic. So if you do have a client who's facing a sentence, who's in DOC facing a sentence over 180 days, then have them reach out to us, or you can reach out to us, and then we can start processing to get that minimum order in place.
Absolutely. Thanks, Kate.
Thank you.
Well, we'll back up one. Sorry about that. Okay, so Kate touched on this a little bit earlier when we were discussing enforcement remedies. And we just want to be clear that although child support as a unit has the authority to enforce remedies, that is usually the last place we want to go. Our intention is to support these families first and foremost, and do whatever we can to work with clients. And so I would say, best practice, really encourage your clients to communicate with their technicians. If they don't know who their technician is, and that happens frequently, they can contact our main line in the office, and we will figure out who their technician is and get them the support that they need. Because if we know the circumstances that these parties are facing or these barriers, there's a lot of work up front we can do to support them before they start facing, these remedies or potential punitive actions. So some of these remedies include suspension of driving privilege, suspension of their recreational license, which would be hunting, fishing, and also passport suspensions, bank account liens, credit reporting, administrative intercepts through their tax returns, insurance payouts, lottery and gambling, things like that. And then we're given the discretion for these remedies, and it is not these remedies are not controlled by the court. So the court cannot overturn a driver's license suspension. They do not have the authority to do that. And lastly, if we've gone through these remedies and we find that they are not working, we're not getting responses from the payer, we're not seeing those payments coming in, then we may consider a contempt action. And again, this is discretionary. Boulder doesn't see it. We don't do a lot of these. Mm-hmm. As I said, we want to really work with families before we even start talking about these remedies, but sometimes they are necessary, and unfortunately we do have to implement them. And I do want to point out as well that all of these remedies that have different guidelines on when they actually would go into effect. Mm-hmm. So it's not a situation where you missed one payment and I'm suspending your driving privilege. Mm-hmm. This is, they have plenty of opportunity. And so again, that's why it's so critical for parents to not fear contacting us. We want to help families. So it would help us greatly to have their private counsel encourage that.
Okay, so I included this slide because I think sometimes it's disconcerting if you have a DR action sort of clicking along and all of a sudden you see child support services enter into a case. I think sometimes parties are fearful that means they've done something wrong or that child support is going to come in and really shake things up. And I think the answer is usually it doesn't mean that anyone has done anything wrong. What it means is that someone has applied for child support services because they want our help enforcing an order or modifying an order, or somebody has received public assistance, in which case, as we discussed, they don't really have a choice unless there's a good cause exception. Child support has to become involved in their case. And under Title 14, the exact site escapes me, but Child Support Services is authorized to intervene in a case. And once we intervene, then we have status as an intervener without any additional action from the court or over the objection of parties. And so, yeah, that's that slide. Okay. And so once you see us intervene, what does that mean as far as like, are you going to see us at every court hearing? Or are we going to be bugging you? And the answer is I think it'll be pretty unusual for you to see us actually showing up at your court hearings. When there's a DR case and there are permanent or temporary orders or any hearing that addresses child support and somebody is actively on TANF, then typically what the department does is file a notice to the court and to the parties, alerting them that there's active TANF and that we will be appearing solely to make sure we're there for the issue of child support. And that's because, again, when someone's on TANF, they've assigned their rights to support to the state. And so that's why we're there. We have a default position that's a really casual term. I probably shouldn't use it, but really it's just that when there's TANF, we want parties to be paying through the FSR. We want the court to be authorizing an income assignment if the court finds that appropriate. And then we do take some positions sometimes when there is TANF about what should be used as income and what's on the guidelines. And again, we don't represent either parent, but our goal is to get the court the information it needs to make an equitable and enforceable order for child support services. An equitable order that child support services can enforce is what I want to say. If there isn't TANF, then it is very unlikely that we're going to appear at a DR hearing, even if there's child support. And for those cases, we'll file a notice of non-appearance, just saying, hey, we're involved for these very limited purposes, and we don't intend on appearing unless the court orders otherwise. And the reason that we don't appear is because I think right now, we're entered into about 2,000 DR cases. Does that sound right? There are a lot of them. So it's impossible for us to appear for every DR action that contemplates child support. And then occasionally the court will order us to appear. I think if there's dispute about child support arrearages, for instance, sometimes the court would like us there and we can provide, something like an arrears calculation or the FSR record. And in those limited circumstances, we might show up. And then you also might see this. You may have seen this if you're in Boulder. If a party files a motion for modification directly to court and we're involved, sometimes the court will order parties to cooperate with child support services. And I think the reason for that is just that there's some level of success in having parties work with child support services. It's not a mediation by any means, but there is a negotiation process. And so I think the court's hope is that by having child support facilitate some of those initial financial exchanges and proposed guidelines, that we might cut down on court time for parties.
Okay. And some other types of hearings that you may be involved with as private counsel, the department might not necessarily be involved in. So we would never appear nor file a notice of non-appearance for hearings that are not involving child support, such as parenting time, decision-making, status conferences, child support contempt actions that are not on our motion, and also continued parenting time hearings, even if they're stemming from the JV action. And so our involvement in those parenting time hearings would be none.
Yeah,
I mean, not at all. Yeah. And so we are just very limited, even in the facilitation of things. As Kate mentioned, we can provide the information and the copies of the motions that they would need to file, but that would be pretty much the extent of our involvement. Yeah. And we will appear if the court requests our presence. Most times they would not, but again, as Kate said, only if there's public assistance involved or something like that. So, okay. And so I just want to speak a little bit about more in depth about what child support services can do for your clients. And I think you'll find that some of these final slides in the presentation will be extremely helpful for you when answering questions for your clients about child support and the child support world. And so I would encourage you to keep this presentation on hand and maybe even print off some of these slides. They can be helpful for you when giving information to your clients, but also you may want to give them as a resource to your client. And so that's up to you, but we hope you find it helpful. So child support, when a client applies for child support services, the county can establish paternity and orders. Parties can file a motion, as we said, for parenting time through their child support JV action, and also will coordinate with private counsel to expedite establishment of right size orders. And of course, if you ever have any questions about the child support world, you can always reach out to us at the department. We are happy to answer questions and help the navigation of this process. We understand it's a lot. We will track their payments and balances, as we said, and enforce the order to ensure payments are made. We'll modify the orders when it's needed or necessary, or if the order qualifies for a modification. And we also assist in navigation of other county services such as food assistance, TANF, employment, housing, and financial counseling. The county has amazing programs that serve our community, and so we are always eager to provide those types of services to our customers. And then when a client is applying for services, child support is not involved until one of the parties physically applies for our services through one of our county offices. There's, again, not a fee to apply, but as a best practice, I would recommend that you advise your clients that that we can only assist them once they apply, and that it's recommended that they bring a copy of their support order to the department when they're applying. Again, they can apply online, they can apply in person at our office, which is located at the St. Vrain Community Hub in Longmont. We recently opened a new hub location in Lafayette. We don't have child support services out of the Lafayette hub yet, but that is something that's being discussed, and we hope that
it is.
Yeah, that would be amazing. Yeah. So even, and we may not have technicians there, but at least we might be able to put applications out, things like that. So that's something that's being discussed. But for now, online or in office. And so it's just really important to make sure your client knows we are not involved in enforcement or in any capacity until they physically apply to us. And I know that seems like it may be an obvious thing, but we have clients asking about this all the time, or they think because I got a child support order in my DR action, we are automatically involved in enforcing that order. And they'll come to the department and say, well, I have a child support case and we can't find them at all. Mm-hmm. That's why. So I think it's really good for them to hear from their private counsel that that's the process that's going to take place. Okay. And so as far as order establishment goes, I'm going to speak on this piece a little bit, and then Kate will have some comments to add as well. But orders are established by the department directly through the courts and as part of a divorce decree. And they will be, if that occurs, they will be given a family support registry account number. We talked about FSR earlier, and the FSR essentially is the bank for child support. They are processing the payments as we discussed earlier. And as a best practice tip, this is something in a space where you may see us getting involved after the fact of order establishment, or if you're, in the process, we would recommend that you ask the court to order direct payments, that direct payments are not even ordered, first of all. It can get very complicated and messy, and we find that the financial piece is where we see a lot of contention between the parties. And so we understand these parties are already going through a difficult time. We don't need to make it more difficult for them. So if we take that piece out, it can help just facilitate the whole process a lot better. And so we would never recommend direct payments. In fact, if a case is opened with our office, we will ask the courts to order that direct payments not be made from one party to another, but rather that payments all would be processed through the Family Support Registry. And also we would ask that the court would authorize an income assignment. We see in a lot of orders that we don't establish or that are done outside of our unit. We see that parties are paying directly, or that they will only authorize an income assignment if a party misses a payment, and that just gets very messy. And the worst part is that nobody's really able to track that or prove that in as well as maybe we could if we were involved, or if it was done through the FSR on a ledger. So as a best practice, we would recommend that.
And I was going to add just a little bit to that, if I could, Nicole.
Yes.
Is that, and we totally understand that in certain cases, of course, that parties direct payments might work and income assignment might not be appropriate in certain circumstances. And I think what we wanted to highlight is that when child support services is involved, these are the things that we do recommend when child support services is involved. And because child support services can't enforce a direct pay order between parties. And the reason for that is that when you have a direct pay order, FSR isn't involved. And so the FSR is what tells child support services units, hey, someone is paying or someone's not paying. So if you don't have FSR telling us that payments are made, then there's no way to prove that payments were made. And there's no way to, adequately monitor what enforcement remedies may or may not kick in. And just anecdotally, I think some of the most complicated hearings that I've done are arrearage determinations, where parties have direct pay prior to child support services being involved. And they come to child support, and there's just a complete full disagreement about what was paid and what wasn't paid prior to the FSR being ordered. So that's really it. Again, I think, sometimes parties, it works for them to do direct pay and not to have an income assignment, but when child support services is involved, that's when these are the approaches that child support takes.
Thank you, Kate. Mm-hmm. And in this slide, we're going to talk about making payments. I know that there's a lot of question around how do I make my payments? How am I going to receive my payments? And again, these are great slides to share with your clients or just to keep for your own reference. All payments by and through an income assignment are preferred and recommended, as we said. If a payment, or I'm sorry, if a parent is unemployed, they are still responsible for making their monthly support obligation, and they will need to submit that payment on their own. We have different ways that they can do that, but we find that our parents who are the most successful payers and the parents who have to worry the least about whether their support was in or what time or did I get paid or not, it's just best to have that done by income assignment. They don't have to think about it. It just automatically comes out of their check. So, however, if a parent is not employed, or they, for example, are a business owner, something like that, they can make their payments online through a reoccurring automatic withdrawal through their bank account. As I mentioned, that's called a RAW. And then they can also pay by electronic check or credit or debit cards online. We also take cash payments, which is amazing, and we find that that's very helpful for a lot of our customers. We have the ability to take cash payments at the Longmont Hub. There's a kiosk on the west side of our building in the entryway. So even if the building is not open, it's not, operational hours, they can still get into that opening at the building to access the kiosk, and they'll need their FSR account number, and they can also use their social security number to access their account. And we find that that's very helpful. Also, cash payments post very quickly compared to other options of making payment. And so if they find that they're running behind or anything like that, that can be a great tool. We also can take payments by mail, but we cannot have clients sending cash. They would need to send check or money order and make those payable to the Family Support Registry and include their FSR account number, court case number, any identifying information that they can. They would mail that to the Colorado Family Support Registry, and we've included the address here for you. One other point that I quickly want to make on this is that if you do have a client who is the person responsible for making payments, they will want to do that I would recommend before the 25th of the month, because it can take a 2 or 3 days to process those payments. So if they come in on the last day of the month and then that payment is processed, it's actually going to assign it to the next month. It's not going to assign it to the previous month or the month it was due in. So child support isn't due on a specific day, it's due within that specific month. And so I just want to put that out there, that it is important to just keep a eye on when you're actually submitting the payment.
And you talk about it in the next slide.
And I talk about it here. Yeah. So if we have a parent who is the recipient of payments, they are going to receive, as I said, that processing of that payment within 2 to 3 days. The parent who makes the payment, it gets submitted to the FSR. FSR assigns those payments then to the recipient. And in our office, we call that person the obligee. So parents receiving support payments have the following options when they select their preferred method of payment receipt. They will need to visit the State Child Support website, which we have listed here, and they'll make their selection for disbursement. So they can choose direct deposit through their bank account, FSR debit card, and there's no bank account required. And also the department is not permitted to disclose the source of payments. Kate talked a little bit about providing information on other parties earlier, but we want to be very clear. A lot of times we'll have a client call and say, well, how did they make this payment, or where did it come from? We cannot disclose the source. We can only disclose the amount that was paid and when it was dispersed. So just want to share that with everyone as well. Okay. And then some helpful tips. The department is not authorized to release information. We've discussed this already a couple of times, except in limited circumstances. Although we would ask parties to provide their financials unless requested for the next legal steps, we will not disclose addresses, phone numbers, or places of employment. And Kate mentioned that briefly earlier as well. The department cannot and will not provide legal advice to our clients, and we will tell them that. A lot of times they will ask us information. There's a lot to know, and we understand that as much as we want to help, may not be in our wheelhouse, and we just simply don't have the authority to do that. Counsel is responsible for submitting their own documentation and relaying their own communications to parties or to the court. So the department is not the facilitator of those communications. However, if you have questions about a process or our involvement, of course, we're always happy to have those conversations with you. So we hope that you find that piece helpful. And then here's the information for our family support registry. We've already discussed a lot of this in detail, but we wanted to have a specific slide available for you so you have a quick reference and you have not only the website, but the contact phone number and also the information for the FSR directly. So we think this will be a very helpful resource for you and for your clients. And again, just to remind them when they get that child support order that they need to create a parent account using their FSR number and select their option for receipt of payments. Anything to add on that?
No, that was perfect. All right. And I just want to do a quick time check. I think we're at 10:52. I think we have 5 or so more minutes. And the next 2 slides are a little bit, they're a little bit dense as far as language and information. So I'm going to do a very quick summary so we have time for questions if there are any. This is to touch on the Uniform Interstate Family Support Act, or UIFSA. This is the authority that allows child support services here in Colorado to enforce another state's order in certain circumstances. So I think really, if you have specific questions about whether or not Colorado can do something with another state's order, I think I'd recommend either typing it in the chat or reaching out to us directly. Just know that child support services can do this in many circumstances, and reach out to us if this is something that your client is interested in doing. And then we can also establish orders even if a party lives in another state. The UIFSA, it's just so much easier to say, allows for other states' child support units to communicate with each other to try to get, let's say, a party served in another state, or another state can establish an order at Colorado's request. So there's a lot of authority child support services units have under UIFSA, and I just wanted to make sure that you had at least that little bit of information moving forward. So you can just skip through the next one as well.
Okay. And again, in the interest of time, I will just briefly touch on community outreach and integrated case management. This is my area of focus in child support. And again, we've talked about a lot of services that we can offer for clients. It is our intention to provide the best services we can for our families, and that they have all of the resources they need, including WIC, Workforce, Genesis program for young mothers, Boulder Housing Assistance, VA programs. There's so much we can do. And there's a lot of programs that people aren't familiar with or don't even know about. And so it's just really important for clients to keep that open dialogue with us. And if they're willing to share their story with us, we can identify areas where we think, hey, this might be a really great resource for you. We think that we could identify these barriers by, using a certain resource within the county. And our integrated case managers, myself and myself,
yeah,
and
this is really just a commercial for Nicole. Okay.
My coworker Sean Cordell, he's also an integrated case manager, and we work closely with these referred families to provide resources for households. So we want attorneys to know as well that we're here to help. If you have a client that you think could benefit from a program, or you have identified a barrier yourself, please feel free to reach out to us and we can let you know what we know of what might be available and help facilitate getting them connected. So really, we just appreciate being here, and we appreciate your time, and we want you to know that we're a resource for you. We're here for you and for your clients. And we'd love to answer any questions that you may have.
Thank you so much. That was perfectly said, Nicole. And I think here comes the part where we don't actually have access to the questions. I think we're going to need a little bit of help if there are any. And if you don't want to type a question into the chat right now, then feel free to send us an email. Sometimes I feel like questions at the end are a little bit of like a quiz, like how well do I know child support, which is fun but stressful. So if you want to email us, please feel free to do that too.
Okay, and the one question that came in, will child support services also enforce payments due through a temporary order when done through you folks, avoiding a direct order? And what steps should I take as an attorney to begin the income assignment process?
So can you read the first part? So I want the temp order, direct order.
It reads, will child support services also enforce payments due through a temporary order, parentheses, when done through you folks, avoiding a direct order, end parentheses?
Okay, so in that circumstance, what I'm understanding is that there's already a court order for direct child support payments. And if that's the case, then child support would not enter another temporary order. We will only establish an order, whether it be temporary or a permanent order, if there's no other child support order in existence. But what we will do is file into the case with the existing direct pay order and file a motion for payment through the Family Support Registry. Without fail, if we enter into a case and it's a direct pay case, you can I will guarantee, as long as I'm in the case, that we'll be filing a motion for Family Support Registry payments. And usually the court grants those pretty quickly. And then there was a second part to that question that was,
Oops, let me get there again. Sorry.
Something that I forget.
That's okay. Let me get there. Ricky said direct payments, not direct order.
Right, so direct payment. So I think the same answer. If there's a direct payment order, then we'll be filing into the case and filing a motion to pay through the Family Support Registry. We'd never intentionally establish a new order over an existing child support order.
Right. And then the second question was, and what steps should I take as an attorney to begin the income assignment process?
That is a great question. If you put your email in a chat, I will send you the statute citation.
Okay. So that's for Ricky. I'll make sure you have all the
presenters
info.
Thank you.
There's a statute that's directly on point for that. If I say it now, it will be wrong. So
let me see.
And
Zoom is a little weird these days.
I would add on to also to Kate, what Kate said, that if we identify, let's say we're working with a client already, or you've given us the heads up that they've applied, however that might look. If there's already a temp order and we're waiting for perm orders, again, the department will enter into that case. We'll enforce the temp order through the Family Support Registry. We would ask that it be done through the Family Support Registry, and we would just enforce the temp order until perm orders are done. And so we wouldn't wait to intervene until there's a permanent order, even if it's not our temp order.
Right.
So I hope that helps too. Good clarification.
Cool. That's it for questions, but I can make sure that your contact, I'll make sure that the PowerPoint goes out to everyone today.
Okay, great.
And if anyone has any questions, you can follow up with them via email.
Thank you so much, everyone.
Thank you.
Thanks, everyone. Have a great day. Bye.
Bye.